right, welcome back. So we'll be talking about Kano now. So we leave out Bauchi, as you may have heard in that report. So two gentlemen join us this morning. Salihu Tanko Yakasai, former spokesman to the Kano State Governor of the All Progressives Congress, joining us from our studios in Kano. And here we've got Muhammad Jamu, Special Advisor, International Public Relations for the Kano Governor of the NNPP. Good morning, gentlemen. Thank you for joining us on the program today. Let me start with you, Mr. Jamu. Well, clearly your party is not happy with this decision, but as you heard in that report, the 9 grounds of the appeal went in favor of the APC candidate. So how's your party responding to this? How are they taking it?
Well, good morning. Good morning, Nigerians listening and watching us from all over the world. When decisions like this are taken, definitely you wouldn't be happy. And what makes us not happy about it, because of the judicial rigmarole happening in the country. We were faced by an instance whereby in a plethora of judicial pronouncements, courts have gone the other way. But suddenly, when it comes to the case, Kano State, judiciary was going the route. In a recent judgment of the Court of Appeal, where 5-man judges sat on the case of Peter Obi versus Tinubu. You know, to make a constitutional pronouncement, it's the full panel of the judges of the Court of Appeal. That's 5. 5 judges. Justice Mohammed Bello, Justice Ani, Justice Bolaji, and 2 others made a pronouncement on Section 131 of the Constitution, subsection C, which is same with Section 177C of the Constitution. 177C talks about the qualification for gubernatorial election. 131C talks about the qualification for presidential election. In determining the case before them, they decided, and equally in pronouncing Section 77 of the Electoral Act, whereby all political parties were mandated within 30 days before the election to submit their voters register. There was a case before them that Peter Obi's name was not on the register of Labour Party. And what did these judges do in determining Section 131? They described and made a constitutional pronouncement that no political party has the power to look into the activities of another political party. And even if another political party has power to look into the activities of another political party, it is already statute bar, because this is supposed to be a pre-election matter. And they went ahead to cite that in plethora of cases which the appeal court and even the Supreme Court have decided, it has been decided that political party activities should be left to the political party. The National Working Committee is the highest organ of any political party. They are to be determined who their member is. And in the case of Peter Obi, they equally mentioned that for the political party, the Labour Party, to have submitted the name of Mr. Obi, they have already satisfied the constitutional means. No political party will submit the name of an alien who does not belong to that political party. And funny enough, INEC introduced a new pattern this time around. Every political party was given a certain code so that issues of the past of multiplicity of submissions of names to the INEC will be taken care of. There was a code that you can use to submit the name of your candidates, to upload the name of the candidates and their forms. And on these forms, you cannot even be able to submit it without including the number of the voters card of your candidates. So the NNPP has satisfied the constitutional rules they were supposed to do. And these judges held that Peter Obi is a member of the Labour Party and has been constitutionally nominated. But here we were faced by another judge saying that 177C has not been satisfied, that the name of His Excellency Abba Kabir Yusuf was not in the register of the new Nigeria People's Party. And funny enough, all election cases before the tribunal or everywhere are so generic. They are in a class of their own. But these judges, in their own wisdom, were citing allied matter in making their pronouncement. I recall I was seated in the court. This judge said that to be able to register a company, you must satisfy the requirement of submitting the names of the shareholders of that company. That is when you meet the requirement. You cannot cite allied matters in a political case. I'm not a lawyer, but from my own experience and knowing what law is, it is common sense. As a layman, I am questioning that you cannot cite allied matter in determining a so generic case, a case of political dispensation, a case of politics in that same regard. There is no embargo on any political party on their registration. And no law has ever said that it is mandatory that names of candidates must appear on the register of the political party.
All right. Well, even though there are attendant issues, but since we've got Salihu Tanko Yakasai on the other side, so we'll let him also give his opening perspective. So, Mr. Yakasai, I haven't heard him here. It suggests that it's not yet Uhuru for the APC. What's your response in terms of what the NNPP thinks of this matter?
Thank you very much, Chamberlain, and good morning to all of us anti-Nigerians as well. I've heard his argument, and I've heard the submissions made by Associate Professor Richard Okocha, and you can see clearly that I think for us in the APC, we followed due process. We tendered all the right evidences and all the right witnesses, right from the tribunal up to the appeal court, where we were able to prove that Abba Kabir Yusuf is not a member of NNPP, and definitely also on the issue of the 165,000 invalid votes as well. You see, the mistake that people make, I always cite this, the mistake that people make is that they do not follow court cases while they are ongoing. They usually wait for the judgment, and then they begin to assess the judgment based on their sentiments and emotions. I followed the case right at the tribunal level, and I kept wondering, because there are instances where the NNPP is supposed to have countered the witnesses or evidences that were presented to the courts by APC, but they didn't. They were supposed to provide their own evidences and witnesses to corroborate their points and their facts, but they didn't. And the courts are places that deal with facts and evidences that are presented by the parties. The APC was able to present a certified true copy of the registered membership of NNPP that was submitted to INEC 30 days before the primary election, and Abba Kabir Yusuf's name was not on that register. And I was a candidate in 2023, and I know the processes that Jam was speaking about. If you write any number on the form and you submit it, it's not the responsibility of INEC to say this is the right number, this is a wrong number. It is just to keep the record, and it is in cases like this when you went to court that you can prove whether he's a member or not. They brought in a register to the tribunal, which was generated 2 months after the election. That is 3 months after the expiration of the deadline for the submission of party register to INEC according to the law. 2 months after. And his name was on that one, but it's not on the certified true copy register that was submitted. There's also the issue of 165 1,000 votes that were removed. According to the Electoral Act, it stated that any ballot paper that is not stamped, is not dated, and is not signed is an invalid paper. And we all know, and we also how ballot boxes were destroyed during the election, and they were snatched and taken away. And so who knows? Perhaps in those cases, some agents stuffed ballot papers in those boxes, and that is why you have some of these invalid ballot papers that were not stamped, dated, and not signed. So these are all some of the facts of the case that have been presented, and of course, the judgment is very thorough. I read the judgment of the tribunal. It's very thorough. I'm waiting
we will be posing the question of the ballot papers to Mr. Jamu
so that they can see the facts of the matter
very soon. But I want to take you up on the issue of the person who can raise whether or not somebody is a member of a political party or was a member at the time when the person was duly nominated. Indeed, Mr. Wokocha, our earlier guest, intervened on that matter, and it wasn't just the Court of Appeal. I think the Supreme Court also upheld that only a member of that same political party can raise the issue. And when he was intervening on what had happened in Plateau, he said it was a different kettle of fish, in the sense that this was about not just nomination now, but Congresses, as to whether or not the processes that also have brought up the governor even happened at all because of an earlier notification by a court order, which seems to have been contravened. There is no such situation here in Kano. So I'd like to know, on what grounds is the APC in Kano raising this, when it is something that only somebody who is within the NNPP that should be raising this?
Let's just like Mr. Professor Richard has stated, there's a constitutional provision, Section 177, subsection C of the Constitution, that stated who a candidate, the criteria for a person to become a candidate of a political party. Section 177, subsection C stated that you have to be a member of a political party and you have to be sponsored by that political party. So we are basing our argument on the fact that, is in the Constitution, and the Constitution is the supreme law of the land. So it is how you present your arguments in court that will determine how the court will rule. Perhaps maybe in the case of Peter Obi, those that are challenging him presented their argument, challenging with regards to issue of primary election, but we are not talking about their primary election. Whatever they did in their primary election is their business. We are not a party to it and we don't care. But what we are saying is that there's a constitutional provision, 177C, that they did not meet. It's the same way as someone not having or attaining the age to be a governor or having the right qualification, to contest that. So it's how you present your case. It is the prayer that you present in your case that the court will rule upon. And we have to wait, just like Professor Richard said, we have to wait.
That's taken. Let me quickly come to Mr. Jamu. He's raised the
one to decide on that. And like I said, we also have, apart from that, we also have the issue of 165,000 votes as well. So we have many cases, we have many facts that are presented, and I'm sure the Supreme Court, I'm very, very confident that the Supreme Court will rule in our favor in all these prayers that we won from the tribunal to the Court of Appeal.
Well, he says they were not challenging the nomination of the primaries that produced your candidate, they're challenging whether he was even a member of the party at all at the time. And that's the basis upon which they have put this before the Supreme Court, which is a constitutional, the Court of Appeal, which is a constitutional matter. How do you respond to that?
Well, that was exactly what I said. I've made that very clear initially when I talked. I cited Section 133, Section 131, which the case of Peter Obi versus Tinubu. It was not a primary election matter, as he referred, is the presidential election matter, is the presidential election tribunal that the 5 justices of the Court of Appeal ruled that no political party has the power to look into activities of another political party, and that Peter Obi has satisfied all constitutional requirement because his party, Labour Party, has submitted his name. And the mere fact that the party has submitted his name, that means he belongs to that political party. That is what the 5 judges of the Court of Appeal said. So citing section 177 subsection C is different from the other sections. If we're talking about maybe your age, educational requirement and things like that, those are in their own class. But the determination of who belongs to a political party can only be determined by the political party itself. Okay. The courts have held that in several instances, only a political party can determine who its members are. Okay, so only a father can say who his son is.
Can you quickly, well, we now have DNA tests, but do you want to quickly intervene on this issue of signed ballot papers, etc.?
Okay, on the issue of the signed ballot papers too, I will advise my brother Salihu to read the Electoral Act sometimes before you come up and put up some arguments. Nowhere in the Electoral Act that the issue of ballot papers has been raised. The issue which the judge, in her own wisdom of the tribunal, based her issue, she cited section 71 of the Electoral Act. And section 71 of the Electoral Act is referring to the issue of result sheet. All result sheet must be stamped, dated, and signed. She made mention of section 71 3 times in her judgment when she determined that on the issue of the ballot paper, it is section 3, section 63, subsection 2 that made reference to ballot paper. And what that section was referring to is that any ballot paper that does not bear the INEC marks on it, the official INEC marks on it, once the presiding officer is satisfied that the ballot paper belongs to the booklet which he has issued, he should go ahead and take a decision and count it alongside. That is what the electoral, that was the...
Maybe I should just read it out. Section 63,
Section 2.
If the returning officer is satisfied that the ballot paper, which does not bear the official mark, was from a book of ballot papers which was furnished to the presiding officer of the polling unit, in which the vote was cast for use at the election in question, he or she shall, notwithstanding the absence of the official mark, count that ballot paper.
So this is the only place where the issue of the ballot paper has been raised. But check section 71 of the Electoral Act. The judges of the tribunal used section 71 in determining the case before it in Kano State. They used section 71 in cancelling the 165,000 votes.
Where it talks about the result must be signed and countersigned.
Yes, the result sheet must be signed, stamped, and dated. That is what section 71 of the Electoral Act says. The Electoral Act book is before you. You can read it.
So you're saying that they shouldn't have used this part?
They shouldn't have used that because ballot papers are not result sheets. They are 2 different. That is it. So
they're 2 different documents.
They are 2 different documents.
Well, I know that my colleague Ayo has more questions for you now. We quickly have to go to Lagos. Ayo.
Well, I'll quickly follow up on that one, Mark. So when we say there are 2 different documents, I mean, a good number of people would agree with you, but isn't it one that validates the other?
Well, if you are talking about that, let's follow strictly what the law says. The law talks about result sheet here, that all result sheet must be stamped, dated, and signed. There is nowhere in the Electoral Act, you can read the Electoral Act from the head to the toe, nowhere in the Electoral Act where it is decided that ballot papers must be stamped, dated, and signed. The only mention of ballot paper is section 63, subsection 2. And what the makers or the framers of the Electoral Act meant there is that they only talked about the official marks on the ballot paper. And that is it. So I don't even know from where those judges will cite Section 71 and cancel 165,000 votes that were duly counted and announced after the election. And then one funny thing, let me even go back to a little bit part of that case. Those 165,000 votes were not even part of the pleading of the APC. APC did not plead them. They were not part of the pleadings. They were not even looked at during the cross-examination. It was after APC have closed their case, all other parties to the matter have closed their case. Those ballot papers were tendered through the bar, how on earth can some things like that be done, you know? So that's just it. The courts have already taken their decision. The Court of Appeal has taken its own route and its own decision. We are going to go to the Supreme Court and wait and see what the decision of the Supreme Court is.
I'd like to stick on that.
I know it is a miscarriage of justice.
Well, I would like to stick with that, you know, for a bit. So as far as you are concerned, given what you know, and you say, of course, that you're not a lawyer, that's granted, what validates a ballot paper? Because, I mean, anyone could just as well have gone anywhere to print. I mean, and this issue of signed and stamped and all of that, that's even one of the things that validates the result sheet in the first place. So how do you think, you know, the law can be, are you proposing that if it's going to be something substantive, that it should be put into the law, if you say, as you say, it is not in the law, that the paper should be stamped and signed by an electoral officer?
Well, we have had several cases. If you remember, even in the past, we have had the case of, I think, General Muhammadu Buhari versus Atiku Abubakar over the issue of serialization of ballot papers. And despite the ballot papers were not serialized, it did not invalidate or even call the integrity of the election at that particular time. So the issue of stamping, dating, and whatever of the ballot papers, if the framers of the laws of Nigeria find it more worthy, I think there should be an amendment to the Electoral Act. If that should be mandatory for elections in the future, there should be an amendment to the Electoral Act to that. So what I can say, we can only rely on what the Electoral Act, because the Electoral Act is the book that guides how elections should be held in Nigeria.
Let me come back to you to you now, Mr. Salihu Tanko, in our Kano studio this morning. You know, so now, as far as you are concerned, it seems like things have been done, you know, for you. But one of the issues that has been raised about this matter is that increasingly the courts, and my colleague Marco mentioned this earlier, the fact that the votes are no longer in contention now. It is the technicalities around it. Is it to say that the people really didn't want your candidate, and consequently they voted for the other party, you know, significantly, which election, according to INEC and the declaration at the collation center, they won? But your party is looking for some technicality and not just the number of votes. Mr. Tanko Yakasai, I can't really hear you at this moment. I can't hear you at this moment. We'll get back to you on that one. So let me come back to you in our Abuja studio while we're waiting for that issue to be resolved, Mr. Jamo. So now, what are your expectations at the Supreme Court? Because these, even though on the one hand we hear it's these are pre-election, there are some pre-election matters, that's the idea of sponsorship or nomination or membership of a political party. But then there is also this other bit, you know, about the fact that, you know, the papers were not signed. Should the Supreme Court, what are your expectations from the Supreme Court about these two issues at least?
Well, my expectation from the Supreme Court, we have always believed that the courts are the last bus stop for the common man, and that the courts are there to do justice And the Supreme Court, I know in several instances, have been able to right some of the miscarriages of justices that has taken place at the tribunal or even at the Court of Appeal. So we have very strong confidence that the learned and wise gentlemen at the Supreme Court will look at this matter dispassionately and look at it from the point of law and determine it. On the issue of membership of a political party, whether His Excellency Abba Kabir Yusuf is a member of a political party, the NNPP or not, the Supreme Court has held in several instances, like I said before, that no one has the right to look at the activities of a political party. And I believe they will do justice and quash the decision of the Court of Appeal. And even on the 165,000 ballot papers that were cancelled by the tribunal and not looked at by the Court of Appeal, I'm sure the Supreme Court in their own wisdom will look at it and see where the errors have taken place and correct it.
All right, so, let's try and see if we can get Tanko in. So Tanko, Saliu, let me, the points that Mr. Muhammad made about section 63(2, I need to get your response on that one, where he was talking about returning officer being satisfied with the ballot paper. So here he says, well, the key thing I think is the point he's trying to make is notwithstanding the absence of the official mark, count the ballot papers. So if I understand this point right, if you have 50 pages on a booklet and 25 are stamped, 25 are not stamped, and the official counts all of them, so that singular act of counting it, to some extent, to a large extent, validates all the others stamped or not signed. So he then wonders, how is it then that the court can rely on this and Section 71 for those deductions? That seems to be the point NNPP is making.
Yeah. So like I was saying earlier on, Mr. Chamberlain, I think it's not just about, it is not about discarding the votes that are valid or stamped. You know, there's a procedure, there's a process, you know, and because in the past, politicians, you know how sometimes they can be, some of them, you know, they create their own ballot papers, they do all these things, they stuff the ballot boxes with all these things, and that is why some of these like a checkpoints, if you must point it that way, are being put to checkmate all these things, you understand, you know. And it is not all the votes that are being discarded, it is only those that we believe are not stamped and dated and signed. So if a party, it is a responsibility of the party to make sure it trains its agents, to make sure it trains all those that are going to stand in for it.
Yeah, but Saliu, pardon me to jump in. On this particular point,
it is also the responsibility of the election umpire.
If you're saying that,
to ensure that its own ad hoc staff that are out in the field also take note of this. But for me,
can you hear me, Saliu?
Since the coming of this electoral act that was signed into law by President Muhammad Buhari in 2022, you know, it has.
Just a minute. We have a few minutes to go, so let me just put in this one so that both of you can respond, and then we'll wrap it up. So, are you suggesting that INEC counted the ballots that were deducted was counted by INEC, knowing full well that they were what? Fake ballot papers or something?
So how will we know? You know, what we are saying is that this was what we saw during the inspection of the ballot boxes that were there. We don't know if who was responsible for that. I'm just saying that everybody at the day of the election is supposed to pay attention to these things. And during the inspection of the ballot boxes that we did in over 32 local governments, this is what we find. So there was nobody there for us to know if it is 100% the fault of INEC or the fault of party agents, whatever it is. But when we went for inspection, this is what we find in these ballot boxes, and this is what we tendered in the court. That's what I'm saying.
Okay. Your closing thoughts, sir.
Well, my closing thought, I think what I will just say is that I want to still call on Nigerians, especially people from Kano, continue to believe in the courts. I am very confident that the miscarriages that have taken place at the tribunal and the Court of Appeal will be corrected at the Supreme Court. And I want to use this occasion to congratulate the presiding judge who was able to deliver justice, the judgment in the case of Kano State, who on the eve of the judgment they delivered against the NNPP government in Kano State was elevated to the Supreme Court. So I want to use this occasion to congratulate him and wish him long life.
Okay, it turns out it's at least, how do you say it in politics? It's a game of interest, not necessarily what? Okay.
Well, we shouldn't even use the word game of interest. We're talking about more than 1 million people that have voted.
I mean the mantra, politics.
Yeah.
It's a game of interest.
Yeah, politics is a game
That's
of
the
interest.
mantra that I was referring
to. That's the mantra.
All right, we have to thank you for coming on this morning. Mohammed Jamu, Special Advisor, International Public Relations to the Governor of Kano State, and Saliu Tanko Yakasai, SSA to the APC Chairman on ICT and Digital Communications. Thank you, gentlemen, for coming on today.
Thank you very much for having us.
Okay, let's say this is the first mail we've got here from Ewuga Abene, who says, on election matters, we, the electorate, will go out and spend all the hours under the sun to elect our candidates. Then the judiciary, made up of 3 or 5 members, will determine our fate. The courts should not be choosing for us. Most candidates that the courts are declaring winner didn't even win at their polling unit. A House of Representatives member in Plateau State was sacked for his opponent that won in just 1 ward. Where is the common principle of natural justice? Okay, well, that's the show today. Apologies to everyone else. Kizito Wayham, who took time to send in his message, as well as all the others. Thank you for your messages, though. We'll see you tomorrow. I'm Chamberlain, so goodbye.
I'm Maupe Ogun Yusuf. Have a great week.
And I'm Ayo Makinde. Have a lovely day.